Okay, good evening, everybody, and welcome to our Thursday night construction roundup. Tonight, we are joined by Mohammed Haque, who is consultant barrister, adjudicator, and quantum expert, and Jon Sharp, who is consultant solicitor, both of whom work for Fletcher Day. Apologies for the lack of vision on Mr. Sharp. We have sound, no vision, but that is the important part. As long as we can hear him, life will be fine. We're also
probably just as well for everybody, Julie, really.
It probably is, John. It probably is. We are also due to be joined by Len Bunton at some point, but it appears that he's running late from a previous appointment. So apologies there. I'm sure he will join us as soon as he is able. Okay, without any further ado, there are a couple of topics that we're going to be covering tonight, including conflict avoidance in practice, looking at liquidated damages. So I believe, Mohammed, we're starting with you. Very active currently in the topic of conflict avoidance in practice, both for us and also some external talks that you've been given. Can you explain why conflict avoidance is so important in the sector?
Sure. I mean, what I'll do is, first of all, thank you very much for letting me discussing this, because I'm a keen advocate of conflict avoidance in any circumstance. As I sometimes say that I'm an Indian origin, Pakistan born, Bangladeshi British, so I had to resolve many things to know what identity better suits me. So yeah, so but why conflict avoidance, or what conflict avoidance is, first of all, if you're not familiar with the topic, is that we know that in construction projects disputes are quite common, and because it's multi-party, it runs for a while, has various uncertainties and all these, but no one's trying to say that we should avoid disputes, at least now. And I'm not an advocate of avoiding disputes either, because it's very legitimate, and it's very good for the purpose of delivering successful projects, that you allow people to talk freely, to give their understanding of a particular clause of the contract or a particular design specification or whatnot. And where does the risk lie? Was it quantified or categorized properly? Was there a wrong transfer of the risk? So people should be allowed to, because we live in a free country, you know, and it's not that, you know, you shut up and do the job, and then we will have another Pink Floyd singing Money. So that's not the idea. Disputes are pretty much welcomed. But then, you know, if you are repeatedly going through the same dispute, or, here is Len.
Len's joined us. Good evening,
Hello,
Len.
Hi. Hi, Len. I've just started to give them a background and why conflict avoidance is important. And then I will ask you to explain what conflict avoidance pledge is, and then I might come back for a few minutes to do its relevance at this point in time to our clients and attendees. Now, as I was saying, that I'm not an advocate of avoidance of dispute. If not for anything else, I'm a dispute resolution professional, so it should be there for allowing me to earn my bread and butter. But I'm a keen advocate of avoiding conflicts. I distinguish one concept from the other in that whereas a dispute is a difference, and a conflict is kind of a dispute which is escalated into a stage where parties are losing their continuous relationship, which is very important, losing their future, and start not punching in that sense on the face, but trying to achieve something which only benefits them. It's not a compromise and not a solution. And then the worst thing is, it keeps on happening throughout the project. And then it's given to some third parties who are not involved at the project stage, right from the beginning of conceptualization to contract conclusion and then delivery. and then defect liability. No, none of them are involved. All third parties come in. They don't have a proper grasp and understanding of the matter. So we've been trying, of course, various ways. Adjudication is the latest tool. Mediation is there to evaluate a particular scope of a dispute and all of these. And the conflict avoidance is actually a new concept added to the line, in the sense that it might have been there in an informal manner, but conflict avoidance is something, a new variety of resolving the differences. And it takes pretty much a preemptive mode, in the sense that when you sense that a dispute is getting like at a stage where it's going to pose more challenges and it'll become unresolvable, in the sense that you might even lose the relationship for future time, you then go to this course of action. A bunch of experts come through to the table. They are an independent advisory board type regarding a particular conflict. And what they then do, they listen to everybody, they talk to everybody, and they try to define what the disputing element is, by listening to the parties. And once they map it up, they then talk to the parties again and find out what it is. And these people are not like a rock musician or a plastic surgeon. They are all construction people from one background or other, have spent their lives in either tunnels or drains or roofs or designing or drawing or quantity surveying. So, and also they have been dealing with the contracts, which are the kind of the core rule book, which runs the whole thing. So they know their subject, and it's advantageous for the people who are involved in it directly, that they can, the mistrust that develops, the ego that hits that, oh no, this quantity surveyor is like, I don't want to use the words, they use it. And this architect is making the life, if you allow this architect fully and freely, he will easily make heaven a hell. So that sort of people, he has given me 89 instructions every time, saying there's no monetary implication or a time implication in it. So these are very common things in construction. But then if you go to a third party, who is a neutral, who might be an architect and an expert and a senior to the architect dealing the thing, and if he comes to the table and say, "No, John, I mean, what are you doing? What are you doing? You should know that you have asked for a variation and that has a time impact. So you should give them some extra time." Chances are that people might sort of listen to it. The outcome is not sort of giving you a sanction, which is enforceable at a court of law or anything like that. But the weight is so high because it's coming from the mouth of an expert, and they try to understand the situation of the project at an early stage. It most of the time helps and resolves the dispute. So all I'm trying to do to our regular audience is to actually ask them to explore and try to resolve some of their disputes, because we are in a very dispute prone situation at the moment. Try this. At least you will know you are in a better, whether you're in a better position or not. There's no harm trying, because it's less costly. And chances are that if you resolve it through this, that might open a new gate for you. So that it is. However, from the institutional perspective, this has been formed into a conflict avoidance coalition, in which all the major players like the CIR, the RICS, the ICE, the ICDS, and the London Transport Board, and so on and so forth, many big organizations were there. And what they have done, they've developed a pledge where you commit yourself, if you sign, you commit yourself to use this mode. It's again not a compulsory commitment, but we are of course trying to make it a compulsory one. So I'm here with Len Bunton, and he is of course a key professional, and for Scotland leading the working group in the CAP. So I would just request Len, if possible, to explain to our audience why the CAP helps, and how that can be used. You know, where someone can go to take advantage of this conflict avoidance.
Okay, thank you very much. First of all, thank you very much for the invitation to join this session. I've just actually come off another webinar which was run by the RICS, and we had 179 people on it talking about this process.
Including me, John.
Len, yeah.
Attending that.
I will explain how this is gaining momentum. I actually think this conflict avoidance process is going to be one of the most significant events in the construction industry in the United Kingdom, because I think apart from the UK, Scottish and Welsh governments all encouraging more collaboration in the industry, I think with the financial pressures the industry has gone through with COVID and the current problems of material shortages and delays caused in contracts, that we are going to have to take a much more grown-up way of dealing with potential construction disputes. I think Mo has touched on a number of the points I was going to make. CAP is an early intervention. The purpose of it is to get people around the table with an independent third party to find out what the issues are and to get everybody working together to find a solution. One thing that occurred to me, there's no textbook. You don't go into a meeting and say, right, I'm going to start at chapter 1 here. You have to be completely flexible, find out what the parties want to get out of something, and then work with them to get a result. Now, the pioneering of this has been carried out over the last 3 years by Transport for London and the RICS. And very briefly, the Transport for London decided that they were having to face significant cost increases in projects because of construction disputes, and they were also facing significant increases in legal fees. So over a period of 2.5 years, they come up with this process. The RICS identified 15 to 20 individuals, and they've completed about 18 projects so far, and TfL have gone public and said there's been a significant reduction in the amount of money that we're having to pay out and a significant reduction in legal fees. And the purpose of what the RICS are doing now is taking this process out to the industry in the United Kingdom. As Mo has said, I'm chairing a working group which is being used as a model, I think, by the rest of the United Kingdom. And we have brought together the industry to meetings, primarily the procuring authorities in the United Kingdom, local authorities, health board, universities, organizations like that. We've brought together all the contracting organizations that represent the membership, and we have mapped out how we're going to take this forward. And we're now making significant progress in terms of creating awareness, which sessions like this do, getting people to understand the benefits of this to their business. The next task is to get these CAP provisions incorporated into construction contracts at tender stage. Now, the RICS has developed a model clause, which I'm sure Mo can send on to anybody who's interested. It's very simple. It simply says, in the event that there are any issues emerging in this contract, the parties will adopt the RICS conflict avoidance process. That does not preclude either party from referring the matter to adjudication, but we don't want to go to adjudication. We want to get it resolved. So the independent person, as Mo has said, will meet with the parties in short order. It can be done very quickly. Find out what the issues are, come up with some non-binding recommendations, and then try to facilitate get them off the table. there's one important thing to remember here. The construction industry wants to build projects. Developers and employers want to build projects. Design teams want to build projects. They don't want projects that are loaded with construction claims and disputes. What's happening in the industry in the United Kingdom is that we're hemorrhaging millions of pounds every year, a lot of public sector money into construction disputes, instead of channeling that into building construction projects and employing people and stimulating the economy. So there's a very fundamental, important aspect of all of this. The one thing that I have seen as an adjudicator is that during a project, if you go to adjudication, the parties never recover from that. Relationships between the employer and the contractor and the design team are shattered. And the one thing that suffers is completion of the project. So having early intervention protects relationships. It gets people round the table trying to find innovative solutions to whatever the difficulty is. And it's working. And I think it's a massive issue for the industry. And what I would like to ask the audience to do after this is have a look at the RICS Conflict Avoidance Pledge and sign up and commit yourself and your organization and your supply chain to finding these solutions. It's working. We've demonstrated it's worked effectively, and it's a much, much more effective method of resolving disputes than adjudication. So that really is a 2-minute analysis more of what we both believe is a very exciting opportunity for the industry. And I'm very grateful to Silver Law, who have supported us in 4 seminars recently with a tremendous take-up across the industry explaining this, and to the Fletcher Day as well for bringing this together and inviting me to participate. Happy to take any questions if there's a Q&A facility. Thanks, Mo.
Okay, Len. I mean, just to supplement Len, because I know John, though we can't see his face, the heroic one, you know, maybe there are ladies in the audience, and Julie has just done the trick. So
it's really not, it's nothing to do with me. I haven't blanked him out for any reason. He has an issue with his camera, I promise.
but just to supplement Len, you know, that even if the organization you're representing, they want to go to litigation or adjudication or arbitration, it could be a good opportunity to evaluate where are you. And if you're a manager in a construction company, it might give you an extra benefit to explain to your own management where is the strength or the weakness of the things that they're thinking at the moment regarding a particular dispute. So all I'm trying to say is, if it's not too expensive, there's no harm in giving it a try and listen to one or more experts about their view. I mean, if there is a dispute, before you take a decision of adjudicating or arbitrating or litigating, you must go to various experts, like to the lawyers, to the quantity surveyors, if it's a design issue, to the designers who are experts in that line, expert witness, and all different types of people you consult. Now, the difference, I still remember that I had a session back in 2018 in the parliament of the all-party parliamentary group, where TfL's CEO was there as well. And I requested him that even if it's not possible to go to a CAP expert before the procurement, just before signing the contract and after the pre-meeting stage when everything is settled, can we not go just after the contract and to analyze and find out who's responsible for what? Mind you, I've been in construction for the last 21 to 25, 22 years now, and I've seen that most of the time, the people don't know what they have signed up to. You know, we talk about risk registers, we talk about transfer of risks and all these things. And then there is a gap between your day of your receiving the tender package, then sending it back in your quotation, and then setting up 100 conditions with your quotation, and then all are gone. And by the time you sign up to the contract, you are faced with or burdened with certain number of risks, which may be completely different from what you have thought internally. And isn't it better to know what your obligations are under the contract? And it applies for everybody, you know. And that, I think, one of the root causes will minimize disputes, will minimize. I mean, if you come to know after going to the expert, who's a neutral, who's not like a partisan mentality that no, let's go, we're going to win this. If they say this and if we can say that, then there is a good chance that something else will happen. You know, that sort of expertise is your own expertise. The person is taking a view from your side. But if somebody can look at it neutrally, listen to both the sides and tell you, this is probably a right answer. I give you two personal examples I'll give you. One is when I started working, okay, a bit of background, sorry, I have to tell this, that I was a counsel in international arbitration in the first 10 years of my practice, and involved in challenges and enforcement of the awards. And things like issue estoppel, things like abuse of the process, and so many other legal concepts were pretty much something my day job. And then I've shifted myself for my personal reasons to adjudication. And I started arguing those things, you know, estoppel, abuse of process, some evidential rules and all these. And I had a mentor type guy, who's of course a senior adjudicator, Robert Sluniski, who's a fellow in the firm where I work even now. I know him for like 10 years or 11 years now. And he used to tell me, he's a barrister, he's just like me, he's a barrister in the quantity sphere. So he used to tell me, Mohammed, you know, I know you're a construction lawyer, but this is a different ballgame, okay? Because adjudication works in a different way. Now, I used to draft an adjudication and go to Rob, and say, Rob, look, I'm going to file it as a referral. What's your view? And certain tweaks you would make, that change this, change that, change that. 10 minutes job. But that caused me to win again and again because he was an experienced adjudicator. He knew the minds of the adjudicators. And he used to tell me, you know, you might say 100 pages, it's not going to work. Adjudicator will work in this way. And that's what the, you know, success rate where it started coming. You know, I was working for a small firm, but people used to queue outside the door. But I have an adjudication. In the projects like Crossrail, Thames Tideway. It's because of that expertise. Similarly, if someone of that type, you know, with a neutral eye, Mark Hensel for that matter, comes in on board and explain to the parties that in his understanding, this is what it is. And it will help you, even if you want to adjudicate, you know, rather than spending thousands on opinions from experts, from lawyers, from whatnot, you know, this is a much cheaper thing, you know, to go for. Yes, Len?
But I wonder, if I just come in on a couple of points just to pick up what you've said. I was asked a question earlier on. Somebody owes me £25,000. There's an issue over design responsibility. Can I use the CAP process to get that resolved? The answer to that is yes. There's no limit, upper or lower limit, on how you should use the process. The second thing is the CAP process will only work in the United Kingdom if it goes right down the supply chain. Because at the end of the day, the supply chain actually building projects. And that's why we're hooking up with the main construction organizations, British Building Federation, Federation of Master Builders and organizations like that, so that their members can get access to this process. And the Scottish Government has been very, very active in promoting this process and insisting that it has to apply to the whole supply chain. So I think that is a vital component of taking this forward. Well, we've discussed this before. I think there's no doubt that the supply chain, must be involved.
Okay. Just out of interest, John, I know we were talking last week at one of your seminars, legal costs in construction adjudication, litigation and mediation. And we were very much talking about the insurance angle of this, third party funders and PI insurance. What's the insurance market's thoughts on this?
Well, the insurance market's thoughts is a bit like the JCT Constructing Excellence contract, which encourages collaboration between all parties and includes the supply chain as well. So before you start a project, you're supposed to all sit around the table and discuss how the project's going to work and taking things forward, etc. But the insurance market is slightly, it doesn't like collaboration. It likes to know where its insured liabilities lie, because that's what they've done for years, and their models and premium ratings, etc., are based on that. Having a model whereby everyone works together isn't something that they necessarily embrace willingly. So they have done it with a couple of other contracts, not so much with the JCT Constructing Excellence contract, simply because it's not become desperately popular. However, in relation to what Len and Mohammed said, I'm in 100% agreement. I've just qualified as a mediator, and I have 2 or 3 cases at the moment which are not, they're not involving huge amounts of money, and mediation is the way to go. So I applaud what Len and Mohammed are doing here. There has to be an end to what seems like a continuing battle between all parties in the construction industry all the time, which is costing everyone an absolute fortune. So I'm very much with what Mohammed and with what Len say, but the insurance industry is going to take, it likes the tried and the trusted. It doesn't like new ideas about risk sharing. Well, you're liable for that, and I'll be a bit liable for that. Really? Well, what am I supposed to pay out on? So it's not keen on that sort of thing. But there is no doubt that we cannot continue in the way we are going at the moment. The construction industry is notorious for not reading its contracts, not executing them properly, and not reading what it signed up to in a rush, I suppose, to get the job, so commercially driven. So if there is a way of avoiding conflict at an early stage, then that has to be the way forward. Just logic dictates that. And I predicted, did I not, Julie, when we did an attempt last November at what Brexit was going to look like before the deal was done? I said 3 things. I said there will be a huge increase in the cost of materials. I said there will be problems in the supply chain because of effectively the tariffs that are going to be imposed between borders. And thirdly, I said there will be a problem with the labour supply. And what everyone's seeing at the moment, from whether you go to your local supermarket or go to your Costa, they've all got signs up saying, I'm really sorry at the moment, we're having supply chain issues. That's because of the Immigration Act, and that was inevitable. So it's not particularly anyone's fault that there are supply issues, certainly in terms of materials and in labour. Arguing about it and suing each other or adjudicating over it is not the way forward. It's an issue that's common everywhere, and there must be a better way of resolving those issues rather than adjudicating, arbitrating, or litigating all the time.
Okay. So also, whilst we've got you on, Mr. Sharp, I believe you have been looking this week at liquidated damages. There was a case.
I'm not going to bore everyone with it too much, but the Triple Point and PTT case is important in terms of liquidated damages. It wasn't actually a case that involved a construction contract. It was PTT and Triple Point entered into a software contract where Triple Point agreed to design, install, maintain and license software to help PTT carry out its business in commodity trading in Thailand. However, in all of the judgments in this case, repeatedly, all the judges have made reference to the commercial rationale for the use of liquidated damages clauses in construction contracts. Now, the reason it was important in this case is that if the difference was huge in terms of who was right and who was wrong. If PTT, because what happened was that Triple Point didn't perform under the contract. There were various stages of performance, and phase one involved 9 stages. Triple Point only completed 2, which meant that PTT had to go somewhere else to get the project completed, etc., etc., etc. If PTT was entitled to liquidated damages for the delay in delivering all uncompleted work to the date of termination, it will be entitled to about 3.5 million.
Ouch.
Yes, ouch. But if Triple Point was correct in its contention, it was only liable to pay liquidated damages for delay in respect of work completed and accepted, it would only be liable to pay about $150,000 US. So a huge difference. So not surprisingly, this went to the Court of Appeal. The Court of Appeal said that as Triple Point never delivered the majority of the work, and there was therefore no corresponding acceptance date, the Court of Appeal found that this clause could not apply. The relevant clause being, if contractor Triple Point fails to deliver work within the time specified and the delay has not been introduced by PTT, the contractor shall be liable to pay the penalty at the rate of 0.1% of undelivered work per day of delay from the due date of delivery up to the date PTT accepts such work. The Court of Appeal has said there was no corresponding acceptance, and it held that liquidated damages clause only applied where PTT did eventually deliver the work itself, not to where another contractor completed the work. Supreme Court, which is not unusual, disagreed entirely with the Court of Appeal and said, well, we're not sure you're right about that. And they were not persuaded by the orthodox approach, but took a more commercial approach. And Lady Arden, who gave the leading judgment, said that, yes, liquidated damages were the correct approach in this case, and therefore PTT have had something of a win, to say the least. But it's not the first time now where the the House of Lords Supreme Court, sorry, that shows my age there, House of Lords, just stepped in, where the Supreme Court have now been applying a common sense and commercial common sense approach. They never used to. They used to leave, well, parties agree that it's our job to simply interpret the contract. But they've done the same with the recent business interruption decision. They've applied a more commercial approach to life. And it looks like they're going to continue to do so. But I'm not going to bore everyone with a huge analysis of the case, but it's just interesting that in that case, despite somewhat woolly wording, shall we say, in terms of the contract, the Court of Appeal came down firmly on the side that PTT could recover liquidated damages. Now, Those clauses where you have stage working, phase completions are common in construction contracts, and the courts very much looked to construction cases when making their decision. So there we are. But going back to the point that Mo and Len have made, I have no idea what the legal cost would have been for an appeal from a first instance decision to then the Court of Appeal and then to the Supreme Court. And whilst you can generally view appeals as more counsel forum, there will still nevertheless have been significant brief fees involved. It may have been much better if the parties had sat around the table and at least tried to agree something, and possibly, although as I said, this wasn't a construction contract, but had something similar to the proposals made by Len and Mohammed been available, may have avoided some considerable amount in legal fees.
Yes. Okay, gentlemen, your opinion on that?
Well, I mean, I would just add that everywhere the commercial sense should prevail at this point in time, not a win-loss type attitude. At the same time, to minimize cost is one important thing, of course, but also to endorse the reality of the time where we are in is another. Because no matter what's going to be, if the materials are not there, materials not there. And if somebody has signed up to an obligation, that they will be responsible for liquidated damages, then the other side will say, I don't care. You know, if you go to China and buy them and fly them in planes, and if it costs you more, I don't care. Now, if that's the attitude, what will happen very soon? They will not get our projects even, because the contractors will say, I'll better go bust, you know. End of the day, these are corporate names, but end of the day, these are individuals who are working as managers within these companies to deliver, you know. So this is why I've been pleading around and asking people that this is a time where we should rethink our resolution strategy and try to understand our respective obligations. And no matter which method you take, you go court, you go adjudication arbitration, it cannot take into consideration anything which is future, you know. It's only a retrospective thing that you post-mortem and find out who was responsible for what. It can't take the situation into consideration, where we are today or where we will be tomorrow. And that's why it's vitally important that we give this, try to give this a try, you know, and evaluate our respective positions better and try to resolve it before it, I mean, 5 years down the track, maybe situations will be different. But A, that we are post-Brexit, B, that we are post-COVID, you know, I think this is a vital thing to try, you know, at this point in time. At the same time, loads of contracts are coming in. And also about John, another thing I wanted to touch on, that is the insurance position, okay? Well, at the time of the contract, they may not care because nobody is gonna spell out what will be the extent of share or anything at the time of the contract. But if there is a potential claim, if that's been resolved at a lower cost or at a lower quantum, that's even better for the insurance people, you know. So I don't see that the insurance will, I'm not saying they'll be over enthusiastic in this, but they will not be very cold either. You know, if they see some kind of resolution between the parties, so they're paying less, you know, I think that could be another incentive for them as well. And that's all from me.
Okay, well, now is the time. If you have questions for any of our panel, Jon, Len, or Mohammed, then please feel free to use the Q&A or the chat facility. We've got some feedback, which I think is coming from Jon. So yeah, but if you have any questions, please feel free to ask. Yeah. Okay. Len. Oh, okay. Len's got a question.
Len's got a question. I wanted just minutes. I wanted to give some If you've got a few minutes, Julie, I wanted to say a few words. About the adjudication process.
Yep.
Just to give you some views.
Yeah.
Number one, I think the RICS's introduction of the low-cost value scheme has been good for the industry. For disputes up to £50,000, there's a fixed rate for adjudicators' fees, and there's also a new summary procedure where the adjudicator will make a decision within 14 days, and the fee is capped at £1,000. And the industry is responding to that, and the RICS are getting a constant request to nominate adjudicators under these processes. So it's worth talking to your lawyers here about that particular process. Also wanted to say that in my view, the jury's out on adjudication at the moment. One of the things I say to my clients is, look, we may be successful here, we may get a result from the adjudicator, but the chances are you still won't get paid. And what I'm seeing now is more and more jurisdictional challenges emerging. I never cease to amaze me at the ingenuity of lawyers to manufacture a jurisdictional challenge from a blank sheet of paper, but they to do it. More power to their elbow. And what you have is these jurisdictional challenges that a party will rely on after they get the adjudicator's decision. And you have to say to your client, well, we're going to have to contest this. We're going to need to engage counsel, lawyers and counsel, and go to court for enforcement. And that's going to take you 6 months and cost you £100,000. And then the party that owes the money will come along and say, look, I'll pay you half of what you've had a decision on. So I'm discouraging any clients we have at the moment to go to adjudication and to try to get matters resolved by negotiation. And I think this is where it reinforces the importance of this CAP process. So having said all of that, the level of appointments that the RICS are making are still at a very high level, about 120 a month. And a lot of these cases settle as soon as a notice of adjudication arises. But it's certainly not as satisfactory a process as it was 5 or 7 years ago. It's clouded with difficulties. The other thing I would like to say, as an adjudicator, once you've read the documents, you get a very, very good idea of what the issues are. And time again, I've looked at a case and thought, if somebody could have got in here and sat between these parties 6 months ago, they could have got this resolved. And I just find it quite incredible how the industry now doesn't communicate. I think we've lost the art of communication in the construction industry. Mm. People call certain other people email cowards, keyboard cowards. People would rather send an email saying, I'm not paying you, than pick up the phone to somebody. And I find that very, very distressing, really, that the communication in the industry has got to that sort of level. I don't think that will ever change, and especially now with the way we're living, using vehicles like this to communicate with each other. Mm. Anyway, I just wanted to chip in these two or three points. I hope people find them interesting.
Understood. Okay, gentlemen, that seems to wrap everything up tonight. No one please have any questions. Just for clarity, we have Len and Mohammed back with us again on the 21st, yes, 21st of September. which is a Tuesday at 6 p.m. Will you be talking about the growth of conflict avoidance in practice and the support from governments? So that'll be an interesting session. Next week, we have Mohammed with us on Thursday, which is adjudication matters, and he'll be talking about enforcing or challenging a decision. And on Wednesday morning at 8 a.m, we have the latest in the Construction Essentials series, where we'll be covering termination. In either case, email seminars@fletcherday.co.uk and we will book you in. It remains only to say thank you to everyone for attending. Thank you to our panelists this evening, Mohammed Haque, Len Bunton and Jon Sharp, who could be heard but not seen. In all cases, if you have any queries about any of the issues tonight and you'd like to email either Mohammed or Jon, you can get them on mohammed.haque@fletcherday.co.uk and Jon Sharp, that's jon.sharp@fletcherday.co.uk. And in both cases, the gentleman will be very happy to answer your queries on any of the topics we've covered tonight. And then there's also Len. Thank you very much for your time. Len is available on len@buntonconsulting.co.uk. So if you wanted to email him regarding taking the CAP pledge, I'm sure he'd be delighted to speak to you or respond to your email. So without any further ado, thank you, gentlemen. Thank you, everyone, for attending, and we look forward to seeing you all again soon. Take care.
Yeah.